Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again, and we are back with a new video on your legal affairs for your CLAT AILET for 2022 and 2023. So if you are new to the channel, please don't forget to hit on the like, share and subscribe button, and also hit on the bell icon for regular updates. Now, if you are not a part of our Telegram channel, do make sure that you subscribe to our Telegram channel under the name of CLAT@Pratham for all these free news, updated articles, and also for our sessions that keep on happening all across Delhi and India. Okay, so coming to the next part is that what is the first news for the day? So the Parliament has passed a bill to merge the three municipal corporations in Delhi. So if anyone who's staying in Delhi might know that the Delhi Municipal Corporation is divided into South Delhi Municipal Corporation, NDMC, that is a North Delhi. Then there is EDMC, that is the East Delhi. And the next one is MC of Municipal Corporation of Delhi, that is MCD. Now, if you know that these are the four divisions and the three municipal corporations that are there, now you can see that the Rajya Sabha on Tuesday has passed this Delhi Municipal Corporation Bill, Amendment Bill of 2022, which seeks to merge the three municipal corporations in the national capital, and it was passed by the Lok Sabha in March, on March of 30th. Now these three will come together. It may be noted that the three bodies of the Municipal Corporation of Delhi were created in 2011 with passing of Delhi Municipal Corporation Amendment Act of by the Legislative Assembly of Delhi. Now, this is why the opposition has criticized the bill, alleging that it disrupts cooperative federalism. So that is why these things are happening. There is a change in the amendments that are being done. So definitely you can see that they have merged the three municipal corporations in Delhi. Now they will be working all together. Now coming to the next news for the day, that the right to be forgotten, we have discussed this earlier also in our previous news slides. Now there is a new case that is coming from on India Qanun, where the Karnataka High Court has directed India Qanun to mask the aggrieved party's name from a judgment record. The Karnataka High Court directed IK to mask the name of a woman who was granted mutual divorce and has subsequently remarried, and if the judgment in question has to remain in the company's database. The woman approached the court seeking her name to be masked in the database of the respondents, Karnataka High Court, India Qanun, and the Indian Lawyer Services says. Right? So the right to be forgotten is there. Now the case is done and it need not be there on the portal. So there needs to be a right to be forgotten and her name needs to be masked out. Now, coming to the next news for the day, that the unmarried daughter can claim marriage expenses from parents under Hindu Adoptions and Maintenance Act, right? So the Chhattisgarh High Court has recently held that the unmarried daughter can claim marriage expenses from her parents under the provisions of Hindu Adoption and Maintenance Act of 1956. Now, what happened in this case was that the bench of Gautam Bodari and Justice Sanjay S. Agarwal held that hearing allowing a petition filed by a 35-year-old woman, Rajeshwari. Now, at the onset of the refer to the section 20 of the Act of 1956, which speaks about the maintenance of children and aged parents, the court further observed that in the instant case, the application moved by the unmarried daughter appellant before the family court was only codified to release of 25 lakhs at a one-time settlement for the purpose of marriage only, and not for daily clothing, food, clothing, and residence. Right? So there was a one-time settlement, and they said that the unmarried daughter can claim these marriage expenses from the parents under the Hindu Adoption and Maintenance Act. Sorry. Now coming to the next is Emmett Till Anti-Lynching Act. The Joe Biden, the President of the United States of America, has signed a law that makes lynching a hate crime in the United States of America. The bill of this war was also earlier passed by the Senate in the US in the month of March of 2022. The Emmett Till Anti-Lynching Act is named after a black boy of 14 years of age who in year of 1955 was brutally killed in Mississippi after he was accused of offending a white woman in the grocery store of her family. Now, by unanimous consent, the bill has been passed in the US Senate, and the bill was passed by the vote of 422 for 3. Now, under this law, a crime can be prosecuted as lynching if a conspiracy to commit a hate crime results in the death or significant physical injury. It also specifies a maximum punishment of 30 years in prison as well as fines that are to be levied. So these are the things that are a part of this anti-lynching act. Now, state can impose reasonable restrictions in the freedom of contract and trade. The Delhi High Court has upheld the amendment of Marketing Discipline Guidelines 2012 MDG issued by the oil marketing companies OMCs to petrol and diesel retail outlet in order to protect the right of the RO's employee. Now, the relationship between the OMCs and their representative dealers is purely contractual in nature, and also the dealership and license agreements executed between the parties. Now, writ jurisdiction cannot be evoked to challenge appointment of arbitrator, right? So the Kerala High Court recently held that the writ jurisdiction cannot be challenged on the appointment of the arbitrator, as the provisions of the Arbitration and Conciliation Act of 1996. The court says that it is the evidence from the provisions contained in section 13 that the scheme of the act is that the grievance of the parties concerning the appointment of the arbitrator shall be addressed in the terms of provisions of the act itself, and there shall not be any judicial inference in the course of the arbitral proceedings. And also, that being the scheme of the act, according to me, if the court interferes in the arbitral process beyond the ambit of the act, the efficiency of the arbitral proceeding would be impaired and the object of the act would be defeated. Right now, this is it for today, guys. I hope you enjoyed the video, and please don't forget to hit on the like, share and subscribe button, and do make sure that you are also subscribed to our Telegram channel. Thanks for joining this live session. Hope you all had a great session, and also do take care of yourself and have a nice day ahead, and do join us on our next session on Friday, which will be very important for all the law students. Do make sure that you are there for that session. Thank you, guys. Have a nice day ahead.